Senhoras e senhores, boa tarde. A organização do evento agradece a gentileza de manterem os telefones celulares no modo silencioso. Neste momento, são iniciados os trabalhos do programa Diálogos com o Supremo Tribunal Federal. A primeira palestra do programa terá como tema o mandato transformador do Sistema Interamericano de Direitos Humanos, ministrada pelo professor doutor Armin von Bogdandy. Compõe a mesa de honra a excelentíssima senhora ministra Rosa Weber, presidente do Supremo Tribunal Federal e do Conselho Nacional de Justiça. O senhor professor doutor Armin von Bogdandy, professor de Direito Público na Alemanha e diretor do Instituto MaxPlanck de Direito Público Comparado e Direito Internacional Público. E suas excelências, o senhor ministro Luiz Roberto Barroso, vice-presidente do Supremo Tribunal Federal. A senhora ministra Carmen Lúcia, ministra do Supremo Tribunal Federal. O senhor ministro Edson Fachin, ministro do Supremo Tribunal Federal. A senhora ministra Maria Tereza Rocha de Assis Moura, presidente do Superior Tribunal de Justiça e do Conselho da Justiça Federal. O senhor ministro Herman Benjamin, do Superior Tribunal de Justiça. Informamos aos servidores interessados na emissão de certificados que é imprescindível o registro de presença junto à Secretaria de Gestão de Pessoas nas entradas dessa sala de sessões. As perguntas sobre a conferência poderão ser enviadas durante a exposição por meio do link disponível no roteiro do evento e também na descrição deste vídeo no YouTube. Os questionamentos poderão ser respondidos ao final da exposição do palestrante, de acordo com a disponibilidade de tempo. Este evento conta com tradução simultânea e está sendo transmitido ao vivo pelo canal oficial do Supremo Tribunal Federal no YouTube. Neste momento, tem a palavra a excelentíssima senhora ministra Rosa Weber, presidente do Supremo Tribunal Federal e do Conselho Nacional de Justiça.
Uma boa tarde a todos. Ao dar início ao nosso evento, saúdo, na condição de presidente do Supremo Tribunal Federal e do Conselho Nacional de Justiça, os eminentes ministros da Casa, meus queridos amigos, ministro Luiz Roberto Barroso, vice-presidente, ministro Luiz Edson Fachin, a querida ministra Maria Tereza, presidente do STJ, ministro Herman Benjamin, também integrante do nosso Superior Tribunal de Justiça, e o eminente professor Armin von Bogdandy, os juízes, os servidores e todos os participantes que nos alegram com a sua presença e também os que nos assistem telepresencialmente. É com entusiasmo e alegria que inauguramos hoje o projeto Diálogos com o Supremo, com tantas presenças ilustres e com a participação, que muitos nos honra, do eminente professor Bogdandy, a quem desde já agradeço efusivamente. Diálogos com o Supremo é um programa de difusão do conhecimento jurídico, criado no âmbito dessa Suprema Corte, em formato de palestras e exposições sobre temas relevantes e atuais. Busca-se, a partir da palavra de especialistas, convidados da mais alta qualificação em suas áreas, oportunizar debates contemporâneos que provoquem reflexões, aprimorem discussões e fomentem ideias, assim contribuindo para o fortalecimento do diálogo entre este Supremo Tribunal Federal e as demais instituições públicas e privadas e a sociedade civil e acadêmica no plano nacional e no plano internacional. Com esta primeira conferência a cargo do eminente professor Bogdandy sobre o tema o mandato transformador do Sistema Interamericano de Direitos Humanos, celebramos, juntamente com a mostra que também hoje estamos a inaugurar, intitulada Convenção Americana sobre Direitos Humanos, 30 anos da promulgação no Brasil, o aniversário de 30 anos da promulgação do chamado Pacto São José da Costa Rica, em nosso país, que se implementou no dia de ontem, 6 de novembro de 2022. Assim como no último dia, 5 de outubro, comemoramos os 34 anos da Constituição Federal de 1988, a nossa Constituição cidadã, de que o Supremo Tribunal Federal é o guardião, por força de mandamento expresso constitucional. Hoje, salientamos a relevância de celebrar os 30 anos da promulgação da Convenção Americana sobre Direitos Humanos. Tal promulgação, rememoro, se fez pelo Decreto 678, de 6 de novembro de 1992, da Presidência da República, depositada que fora a carta de adesão a essa convenção pelo governo brasileiro em 25 de setembro de 1992, quando entrou em vigor no Brasil. E aqui cabe sublinhar que tal ocorreu em contexto social em que se consolidava, o ano era 1992, o processo de redemocratização no país, alicerçado no respeito e na garantia dos direitos humanos. Em tempos procelosos como os atuais, de reiterados ataques à democracia e ao Estado democrático de direito, faz-se imperioso, mais do que nunca, reafirmar a vinculação do Brasil à proteção dos direitos humanos e ao Pacto de São José da Costa Rica, marco significativo do compromisso assumido pelo Estado brasileiro com o respeito, a proteção e a realização de direitos, bem como sua integração ampla e efetiva no Sistema Interamericano de Direitos Humanos. Enfatizo que o preâmbulo da Convenção consigna, aspas, seu propósito de consolidar neste continente, dentro do quadro das instituições democráticas, um regime de liberdade pessoal e de justiça social fundado no respeito dos direitos essenciais do homem. Nessa linha, e inspirado por esse propósito, é que o Supremo Tribunal Federal hoje celebra o 30º aniversário, repito mais uma vez, da promulgação do Pacto de São José no país, com a honrosa presença do professor Bogdandy, diretor do Instituto MaxPlanck para o Direito Público, Comparado e Direito Internacional de Heidelberg, Alemanha, que nos brindará com sua percepção sobre os caminhos interamericanos para a transformação. A apresentação do professor Bogdandy será feita na sequência com a proficiência e a elegância de sempre, estou certa, pelo ministro Luiz Roberto Barroso. Enfatizo apenas que o professor Bogdandy, no Instituto, sob sua direção, cedia pesquisas voltadas à realidade latino-americana, que envolvem professores de diferentes países, permitindo, assim, a enriquecedora pluralidade de olhares, sempre bem-vinda e prestigiada nesta casa. A palestra seguramente nos fará mergulhar no Sistema Interamericano de Direitos Humanos, rememorando momentos de interação dessa Suprema Corte com o sistema regional em busca do constante aprimoramento da jurisdição constitucional. A mostra, por sua vez, tem caráter itinerante. Hoje está situada aqui, na sala de sessões da nossa primeira turma. A partir de amanhã, poderá ser visitada no hall de acesso ao plenário. Os painéis trazem informações básicas sobre a Convenção, além de infográfico com os países signatários e linha do tempo, destacando antecedentes históricos dos direitos humanos na América e a recepção da Convenção Americana no Brasil. Em suma, nosso diálogo demonstra a importância da consolidação democrática e humanitária, não apenas dentro das fronteiras do Brasil, mas em toda a região, em busca de transformação que proporcione igualdade, inclusão e justiça social. almejo que possamos todos, nesta tarde, refletir, compreender e comungar da identidade interamericana que nos fortalece. Muito obrigada. E eu saúdo ainda a querida ministra Carmen Lúcia, né, que igualmente nos honra e alegra com sua presença.
Agradecemos as palavras da excelentíssima ministra Rosa Weber e convidamos a Sua Excelência, ministro Luiz Roberto Barroso, vice-presidente do Supremo Tribunal Federal e do Conselho Nacional de Justiça, para a apresentação do palestrante.
Muito boa tarde a todos. Por estranho que possa parecer, me pediram que fizesse a apresentação em inglês, portanto, que vai ser a língua oficial do evento e, portanto, it sounds a little bit awkward, but I'm going to do that. And I want to greet our Chief Justice, Justice Rosa Weber, Justice Carmen Lúcia, Justice Luiz Edson Fachin, and Justices Maria Teresa and Herman Benjamin. It's a pleasure to have you all here. And it's a very special pleasure to have Professor Armin von Bogdandy here. It's a great pleasure to be able to make this introduction. I've met him in Heidelberg some 3 years ago in a wonderful seminar that the MaxPlanck holds every July to discuss global issues and very particularly to discuss issues relating to Latin America, which is a great opportunity that we all have. Professor Armin von Bogdandy is the director of the MaxPlanck Institute for Comparative Public Law and International Law that is in the wonderful, gracious city of Heidelberg. He's also professor of public law at Frankfurt University in Germany, and he has received several international awards. He develops 3 lines of research in public law that I would like to highlight here. The first one is on the European legal space. The second one is on the concept of international public authority. And the third one, the idea, very original idea that he's going to expose today of a jus constitutionale comune in Latin America, which is the object of this lecture today, in which, in his argument is, he tries to identify a very important dialogue between the Inter-American Court of Human Rights and the national courts in Latin America, developing this idea of the existence of a common constitutional law that kind of binds all these countries. So people are here to listen to you, not to me. So I'm very happy to turn over to you. You have the floor, Professor. Thank you very much once again for being here with us.
Good evening, ladies and gentlemen, Mr. President, Mr. Vice President. It's such an incredible honor to be here with you today to speak. And let me just... And what is to speak here at the Brazilian Supreme Court? So why is that so important? Well, of course, it's the Supreme Court of Brazil. It's a very important country. It's one of the pillars of the free world. But there's more than that. Your constitution is from 1988, and from 1988 on, there was a very important movement all over the world, and that was the idea that constitutional courts are truly important when it comes to uphold democracy. That was a basic idea that came with in those years, 1988. Now, in the last years, that conviction and that hope has been severely shattered. There was the very famous constitutional court of Hungary that led the democratic transformation in Hungary. Now it's a puppet of an authoritarian government. There's the very important Constitutional Tribunal of Poland, which also was a beacon of democratic transformation. And now it's an instrument of a government. There's even the UK Supreme Court, the UK Supreme Court, perhaps the motherland of the rule of law. And it did not withstand Boris Johnson. So many people started to be very critical and say, what can constitutional justice deliver when things go rough? But we have your example. Now, we have the example of the Brazilian Supreme Court that when things go rough, constitutional adjudication can make a true difference. And that is not the only reason why I'm so happy to be here, and that is not the only reason why your court has such international visibility. But believe me, it's one reason that certainly counts. And for that reason, I'm so grateful to be here in this moment to speak to you about things that are important. And the occasion is 30 years of the ratification of Brazil by the American Convention. And of course, that has been the breakthrough, with Mexico and Brazil ratifying that, and then some years later accepting the jurisdiction of the Inter-American Court of Justice. That was a historical moment that brought something to the world, and that is the something that I want to speak about. Now, I have to. I was presenting, and what I will be presenting is that. Of course, it is my idea of what is going on in Latin America, and that is far away. But it is dear to my heart to state that this is not a lonely exercise from Germany, but that comes in a very deep interaction with many colleagues from Latin America, and one and foremost of Flavia Pövesan. I'm so glad that you are with me. We cooked that up together with Eduardo Ferrer-Mercrega, with Mariela Morales Enthusiast. It was the four of us who cooked up what we will be presenting to you. So it's you will hear my interpretation, but I count on you if things go rough. Yeah, so that's and it's almost 20 years that we are doing that. So it's 30 years of the ratification, and it's 20 years of our collaboration. So it's a very happy moment to do this here. Now, what is the central idea that I want to convey to you? It's the idea that in Latin America, you have created something great. And that is that you have created what I call here a transformative constitutionalism on a regional basis. And that is, as I will explain to you, that is an addition to the judicial heritage of mankind. I think it's a very important point. Now, one thing that I want to make clear from the very beginning, you see that on my choice on the first picture. What do you see? I'm speaking of the Inter-American system. But what is the court that you see? It's the Brazilian Supreme Court. So perhaps the core idea of that talk is that the Inter-American system, it's not just the court in San Jose, and it's not just the commission in Washington, D.C., but it is also this court and the other institutions that in this country are using the Inter-American system to advance the situation. That is a core idea, and perhaps we might discuss it. Of course, that can be a challenge, but that is, also for the sake of discussion, the very first picture. It's I speak about the Inter-American system, but the Inter-American system sits in this house. This house has a very important role for how this system goes, not least because it's Brazil. It's the biggest country, it's the most powerful country. It's a leader of the global south. So what happens here? It is it is truly important. So we have that transformative constitutionalism, but that is a thing that is to be developed. And of course, also what comes out of this house here, it is very important for what that happens. Now I brought you some slides. I put the slides in Spanish, because I think it's easier for you to understand that. I did not trust Google in translating it into Portuguese. So let's try to. So what I will try to convey to you the idea that there is this addition to the global juridical heritage, which is this transformative constitutionalism, and that this house here is a server, is a center of this transformative constitutionalism. So I wanted to explain that, to develop that in 3 steps. I have a lot of time. I was awarded 45 minutes. You know, that's incredible. When you go to international conference, they give you, if it's a lot, 20 minutes, and that's the keynote address. So here I have 45. You're so generous with me. So I have time. So I will try to do it in 3 steps. So first of all, I want to explain to you what we, Flavia and myself, and it's a whole group now. I think it's almost 400 people who are working with this approach, what we understand by Latin American transformative constitutionalism. So what is it? That's the first question, the first research question. And then the second research question, the second thing I want to develop is, why does this transformative constitutionalism, why does it operate through a common constitutional law? Why is that idea of a common constitutional law so important? And I will show you that is the specific trick of Latin America. That is why here it works better than in South Africa, where the concept comes from. Yeah? So that is the second one. And then the third one is that you might say, well, is there any true impact? Isn't it just something that, paper with letters on it? Does it have any impact in reality? And of course, that is a true question, because many people say, well, look what happened with the decisions of the Interamerican Court of Human Rights. Look at the compliance figures, and you see that the compliance is not so good. And that for many reasons, for many people might think, well, because the compliance is so bad, then it's really nothing, it's a futile exercise. I will tell you that is not the case. So that is the program for today. Now let's then come to the first question, and that is the question. So what are the core elements of this transformative constitutionalism? Now, if we look at constitutions, we see that many constitutions today have come objective the idea of a democratic transformation. So the first one in that sense was the Mexican Constitution of 1917, followed shortly afterwards by the Weimar, the first Republican German Constitution of 1919. So the idea of these constitutions was not just to set up the organization of the state, not just to set up the bureaucracy, the apparatus of power, but also to address and change society. That was the idea of those constitutions, and to change society with the idea of democratic inclusion. At the time, they didn't use that concept, but I think today we understand what democratic inclusion means. And that was the idea of Querétaro. That was the idea of Weimar, and to change the situation of citizens in a very difficult situation. So the situation in Mexico in 1917 was terrible, but the situation in Germany in 1919 was also terrible. You know, we just had lost a world war, and we just had the Spanish flu. Yeah, so it was a terrible, terrible situation, And the idea was that we need to change the country. And we need to change the country, and that the Constitution has a role in that process. That the Constitution has a role in that process of having more democratic inclusion. So that was the new idea that came with that Constitution. And then many other constitutions have followed that path. Very famous in that respect is the Italian Constitution of 1947, the Portuguese Constitution in 1976, and the Brazilian Constitution in 1988. So we have had a good, to the beginning of the 1990s, we had a good number of constitutions that in the constitutional text we have the idea of democratic transformation, of democratic inclusion, of making the country a fairer place. But transformative constitutionalism is something more. Transformative constitutionalism is something that is brought up in the 90s. And in a way, it comes with all the legacy of the 90s and also with the problems of the 90s. Now, today we know, for example, that human rights is not the solution to all problems of the world. Yeah. But still, we know that human rights are very important. There's nothing that is is a solution to all the problems of the world. It also came, and that was important, it came in the time with the Washington Consensus. And indeed, there were a number of people who linked the idea of human rights as they blossomed in the 90s with the economic model of the Washington Consensus. And that also is a problem because today almost everybody sees that that model of the Washington Consensus does not work. Who was the last one to find that out? It was the last British Prime Minister. You know, she took her 40 days, or the British people 40 days to find out that the Washington Consensus is not something to have a country. So there something happened. And they happened, and that is now, we are coming to the phenomenon of transformative constitutionalism, and that is something that comes from what today we call the Global South. And I think that is important because I think it's the first global juridical idea that is coming from the Global South and not from the Global North. So here something specific was invented. And what is that? And it was invented in two courts. One is the Colombian Constitutional Court, the Constitutional Court of Colombia, and the other one is the Constitutional Court of South Africa. These are the two courts that really brought that to the fore, and then many other courts took that up. In particular, we will see then the Inter-American Court, but I also understand that also the Brazilian court is moving that path. Now, what is the new idea, in my understanding? The new idea is that the legal system as such, that's to say the judges, the courts, but also, importantly, the attorneys, because if you don't have attorneys who have those ideas, nothing like that will come to the courts. So the core idea is that the legal system, the judges, the courts, the attorneys, they start using cases to give a contribution to deep social change that advances to more democratic inclusion. So it means that you have problems that before we thought they are just too big for the legal system to address them. Now they say, no, we look at systemic deficiencies. We look at very serious situations, and we, via judgments that come to us, we try to give a contribution so that the country moves out of those phenomena. So that was in South Africa, of course, apartheid. To overcome apartheid and all what that meant. And in Colombia, it was the situation of almost state failure for narco-terrorism. So in that situation, there was a new constitution, and now what they did, they developed interpretations and applications of the law in interpreting the cases in order to address that situation and to help the country to address those phenomena. Now, in Latin America, the new constitutions that came in the 90s, like the Colombian constitution, but also the Brazilian constitution, that phenomenon of the new constitutions that came in those countries, it was often termed as neoconstitucionalismo. That was the way how it was very often termed in Latin America, and that's a fair concept. But I think that the concept of transformative constitutionalism is better because it conveys better the idea of what it is about. Neoconstitucionalismo does not give you any direction. Whereas transformative constitutionalism gives you the idea that you are working with the constitution, that you have a constitutional mindset, and that you are using this constitutional mindset in order to transform the country. So it is not about revolution, certainly not, but it is about a process that has a starting point and that wants to come to change something deep. That is the concept that has been invented by Karl Clare, who is a professor, a US professor from Boston, and he conceptualized with transformative constitutionalism what was going on in South Africa. He had very good contact with South Africa, and he said, well, what you are doing, that is transformative constitutionalism, and I think it's a very happy concept. For that reason, I think it's better than neoconstitucionalismo to address what it is on. So it means to interpret the law and to apply the law in critical cases, so to develop precedent and judicial practices in order to address systemic deficiencies, grave problems in a society, in order to help the society to overcome that. Now, of course, I'm speaking of Latin America, and of course that it's a very broad concept, and we know that the countries in Latin America and even the regions in Latin America are very different. So of course transformative constitutionalism is not a one-size-fits-all concept, but of course it is something that has to be adapted to the various countries. For example, we see that Brazil has a very strong judiciary and very, very independent judiciary. We see that in other countries, the independence of the judiciary is a core problem. So in some countries, you have a transformative constitution that very much works on the idea how to strengthen the independence of the judiciary. That, fortunately, is in Brazil. It's not a problem. So here you have different problems. So it's not a one-size-fits-all, but nevertheless, there are some features that you find more or less in many countries. So one problem that you have in many countries is that you have systemic violence. Then you have, in many countries, very serious violations of people who are in a specific situation of vulnerability. And then, of course, you have, in many of these countries, the legacy of dictatorships or authoritarian governments. And actually, we see that the past of dictatorial, of military dictatorships is not really so much past. Somehow it continues to be a threat, at least, that needs to be addressed. And then also there are many people who say that the deep inequality that you have in many Latin American societies, that also is a structural problem that needs to be addressed. So we have these problems, but then also we have had much change, very important change that brought us to a different situation. And that is because something in the 70s happened. Because in the 70s and early 80s, you had a period of particularly grave violations of human rights. So, of course, the most famous cases are Central American countries, as well as Argentina and Chile. But, of course, we also know that in Peru things were very bad, and also Brazil has had problems in that respect. And so what happened in those countries? What happened is that the opposition and that is important for what will then come later, with a quite significant help from outside, started to use human rights to combat those situations. So, whereas before human rights and fundamental rights were mostly a decoration in the constitutions and in the legal order, so it was not really something that the courts and the attorneys and the population worked with. Now, in the fire of repression that you had in the 70s, that changed. So human rights became a defensive weapon, and a weapon by which the opposition, the democratic opposition in those countries, attacked those regimes, and that helped to fall. So for that reason, human rights became important in important discourses in the national societies. Perhaps, as I see it, the most visible of that was the Nunca Más. Yeah, so we all know that from Argentina. That was the most important report on the oppression. But that said something. So it Nunca Más what? It was Nunca Más serious violations of fundamental rights. So that was the basic lesson that was taken from that repression, and it was then thought in the processes that through rights, both you can withstand that repression, but also through rights, you can address the situation that led to dictatorships in the first place. So that is why rights became so important, and you introduced very important rights in the Brazilian constitution, and that happened in almost all countries. Either they had new constitutions or they added new rights to their constitution, as in the case of Argentina. But that was not all, because the constituent power took on one important lesson. And that important lesson was that, so I don't know so well the situation in Brazil, you will tell me, but there are many studies that in Chile and in Argentina and in Mexico and in Honduras and in Guatemala, international human rights and international human rights organizations were key in the transformation. So the democratic opposition has learned that in order to stabilize, to come to a democratic regime, and then to stabilize a democratic regime, to lock in international human rights. So it is an historical experience which then was elaborated by many constitutions by giving international human rights treaty a specific role in the domestic constitution. And that is not small beer, because we know that Latin American countries have a very strong idea of sovereignty for obvious reasons. For obvious reasons, sovereignty is a very strong concept, and the traditional approach was to give international law a very small place in the domestic legal order of Latin American countries. But for that experience, that is for the experience how much international human rights and international human rights organizations helped to address to fight and to overcome that type of repression, international human rights were given a specific role in domestic constitutions. So in most countries, they have a rank over the normal statute, and in some countries they even have constitutional value. So locking in the clauses in the domestic constitution that give a specific role to international human rights, see, that is not just a technical thing somewhere in the constitution. It is a core insight from one of the worst periods that these countries have lived through. And that development then was brought ahead by Brazil and then Mexico becoming part of the American Convention, and then in the late 1990s submit to the jurisdiction of the Inter-American Court of Human Rights by the decision of the legislative organs. So it is not giving up sovereignty, but it is part of Brazilian sovereignty to live with that convention and to accept and elaborate and follow the decisions of the Inter-American Court. Now, and I think that is the basic thing, why the Inter-American system has gained that role in many countries, and we know it is uneven, and it also depends on many things, whether it is more or less, but I think there's a basic understanding that many legal operators in those countries have understood that to fulfill the mandate that they have received from their constitution, so for you from the Brazilian constitution, that you can fulfill that mandate better if you do that together with the Inter-American system and with the other countries that are in the Inter-American system. Because that tells you, and that brings us to the common, that in the process of democratic inclusion, you are not alone. You can count on other countries, you can count on colleagues in other countries, and you can count on international institutions. And we have seen, and there's a rich experience, that democratic inclusion goes better if a country is not alone in that process. So that is then the point that Latin America has this idea of transformative constitutionalism, and it has it in the domestic systems, but it also has it at the inter-American level. So that the Inter-American Court, but also the Inter-American Commission, help and give impetus into that process. For that reason, the Latin American transformative constitutionalism is a regional phenomenon and not something which is limited to only one country. And indeed, it is not only the courts. As I told you, it needs the attorneys, but you also have quite a number of fiscales. You have the people who are working in the specific administrations, the human rights administrations. They're also linked up to that system. So it is not just something of the legal system, but of course, the leadership in those processes, and I will come to that, comes from the Supreme Court. How that is elaborated, that goes by the precedents that the court gives. Now you will ask me, how is it possible that the American Convention has a transformative mandate? Because, as we all know, the American Convention is from 1969. And in 1969, none of the governments that signed the convention at the time had in mind democratic inclusion. Indeed, in most countries, you had repressive governments or even authoritarian governments or even dictatorships. And we all know that the American Convention, why do we have the American Convention? Well, it was a symbolic piece against Cuba. That's why we have the American Convention. It was thought as a policy tool to put pressure on Cuba. That was how it was created, and it was a copy of the European Convention on Human Rights with some small additions, like the Article 2. Probably at the time nobody really knew what it was, but the Article 2, that you have to adapt the domestic system. That's new, but otherwise it was just a copy of the European Convention, and it was meant as a piece of policy towards Cuba. And nobody thought at the time that that would have any impact in the region, and certainly not a transformative impact for more transformative for democratic inclusion. But then something happened, and you are all constitutional lawyers, so you know that a constitutional texts, when you have important changes in society, the meaning of a constitution changes. And the same happened with the American Convention, because you had the Brazilian Constitution, you had the Colombian Constitution, you had the new Peruvian Constitution, you had the constitutional reforms in Latin America, and all what I told you before. That's to say, when these countries started with the neo-constitucionalismo, that's to say, when they started to use constitutional law to change their countries for being more inclusive, that new meaning fed into the American Convention on Human Rights. And the justices, the judges at the Inter-American Court, they started interpreting the American Convention in the way that their peers in the domestic systems now started doing it. In particular, following the example of the Colombian court. So they saw a window of opportunity for their court, that before nobody knew what would be the mission and its function, that now they say, now we have a possible positive role to play, and let's go that way. And they started with this incredible jurisprudence to support democratic transition. And luckily, many operators in the domestic systems understood that this is of a great help, and they decided to see that as legal and legitimate, because they accepted it, sometimes with difficulties, but also even the chancelleries. Just think of Uruguay. After the Caso Hellman, I think you all know Operación Condor, Caso Hellman, you all know what that is, the Caso Hellman. And, Uruguay, who had the amnesty law, and they had a confirmed by the Supreme Court and a referendum, and then the American court said, no, that's not good for us. Now, who is the person that Uruguay sends as the new judge to the Inter-American Court? It's the judge dissenting on the decision of the Uruguayan Supreme Court. It's the judge who said, we have to follow that precedent. And it is that person that they sent now, and who is now the impressive president of the Inter-American. So what does that tell us? It tells us that although the government of Uruguay was certainly very angry of that, and there was a very serious tension, nevertheless, they understood that they have a very high stake in that system, and that they want that system to run the path that it has started, even though it is very annoying to them. And the same is true with Brazil. We were thinking, what would be the next judge that Brazil sends to the Inter-American Court? So they send a judge, and it's what I hear, he is working with the system. So it is very interesting that even governments who are very critical of individual judgments, they continue sending judges who are in favor, who work with the system, which is impressive because there are just 7 judges. It is, I think it's evident to all of us that, when there came the letter of the 5 presidents, the Brazilian, the Argentinian, the Colombian, the Uruguayan, and the Chilean. You know, the 5, you know, they could switch the court like that, but they did not. Because even in those conservative forces, apparently there's a conviction that their country is better with the Inter-American system in the way it is operating. Now. Now, that brought a new way of understanding the law. And the Inter-American Court is pushing that very strongly. Now, what kind of laws do we have? There's a first way of the law, and that is the repressive law. That is to say, you have law, but they use the law to repress certain parts of the population. So that is the most ancient way on how law is used. So it's repressive law, and that you have in all legal systems. Then a more evolved form of the law is autonomous law. Now, what is autonomous law? That is the law that we need for a functional economy. So that you have contracts, and the contracts are working according to their logic, that you have torts, that you can set up companies. That is the autonomous law, and that is what mostly is done then, developed by most Supreme Courts when they do civil law. That is autonomous law. But then you have responsive law. And responsive law is a law that is interpreted in light of the situation that the court finds, and in light of the social conflicts and the social deficits that you find in a country. And that type of responsive law, that then comes very often with human rights. That is the language of responsive law. It comes with the proportionality principle, because that allows to respond to the situation at hand. And it comes with something for which the Inter-American Court became so important. And that is the victim-centered approach. So that they truly look at the person who stands in front of it, the person who is afflicted by a situation, that you look at that person. And I can tell you from Germany, that is not the normal way how we look at law. The victim or the plaintiff, that is something that brings the whole thing into motion, but it's certainly not what stands at the heart of the legal process. Now, the responsive law that the Inter-American system is proposing is a responsive law with a victim-centered approach. And it's important to see it's not only the court. You know, there's another institution. It is the Commission, the Inter-American Commission, and the Inter-American Commission feeds into further network with a number of reports that have been important in addressing a number of situations. Now, these two institutions then, for example, recently in the pandemic, I think they played a very important role when it came to how to deal with the pandemic. So first of all, we had the human rights language, and that is an important way to, it is our way, our specific, you know, it's not just doctors who decide what is going on in the pandemic, but we, the lawyers, we have our own language to frame the problem. And what is our main language to frame the problem? That are human rights. Of course, with human rights, we see the complexity, because on the one hand, we have the human rights, and human rights, they have the need, and that's the liberal way, to respect. So there's the freedom of work, there's the freedom of assembly, there's the freedom of study, there is the freedom of worship. So to infringe those rights is very serious. But on the other hand, we have the duty to protect and the duty to fulfill, and there's the right to health. And then you have to find ways to deal with it, and there are complex questions. But us being lawyers, we don't leave it to the technicians, we don't leave it to the medical doctors. Us as lawyers, we have our own standards to assess these issues. And now the new theme now is climate change. It's a similar thing. It started as a totally technical questions, and law was just instrumental. But now, with the climate cases, we, the lawyers, are starting to have our own voice, how to deal with this deep social problem. I'm already at 41, so I have to rush up now. Why is that constitutional? Why is it by a common law? I go fast here because I think it is evident. It is a common law, first of all, because the convention rights are shared among all those countries. And it's not just the convention. And these convention rights are not just international law, but they are built into the fabric of the domestic law. The same is true with the institutions. They are common institutions, the Commission and the Court. And the decisions of those institutions are built into the fabric of the domestic law. Of course, here are numerous doctrinal questions. There's the block of constitutionality. There is the conventionality control. Now, how deal with the conventionality control? There are a lot of very interesting legal questions, but at the end, it is accepted that there is the block of constitutionality and that there is the conventionality control, and that means that this law is common to all of us. Moreover, there's a very thick layer of horizontal interaction in Latin America. Now, I understand that with Brazil that is different because at the end it's a different language. It's a continent in itself. It's a very big country. But for example, in Ecuador, they are teaching constitutional law at the university with cases from the Colombian Constitutional Court. You know, that is how deep the integration is in many Latin American countries, that they use the precedents of the various countries in order to build a common legacy. And I think for all these reasons, it makes sense to speak of a common law. But there's one more element, and then I stop with this, and that is when the judges are starting to see that they are national judges, but they also understand that they are also inter-American judges in the way that they're applying the Inter-American Convention. And that is not, and I have heard judges referring to themselves that they are inter-American judges. So I saw the president of the Supreme Court of Mexico, and he refers to himself as being an inter-American judge, a Mexican judge, but also an inter-American judge. So the inter-American system already has an element of identity building. Now, and so that is the point. Now the last, and then I will stop. I was a little slow. So what is, and with that I start. Now, what is then, does it truly have impact, this system? And so one reason is that we do have cases. You know, if you do have cases, if people bring cases, that's, I think, a very evident thing that it has an impact. But of course, then people come to the question of compliance, and they say, well, but look at the Inter-American Court and look how bad compliance is. It does not have an impact because you have so much non-compliance. But here is my argument, and it is twofold. The first is, if you want to be a transformative court, that is, if you're a court that wants to address systemic deficiencies, you cannot go for compliance, because it's clear that it is very difficult to have transformations to overcome systemic deficiencies in our societies. For that reason, if you feel that you have the mandate to address systemic deficiencies, you cannot issue decisions that are easy to comply. Many of the decisions are very hard to comply. Indeed, some decisions are impossible to comply. You know, when the Inter-American Court tells Mexico to find the rests of a person that has been disappeared 30 years ago, it's evident that it will never be complied with. But why does the court go that way? It goes that way because these decisions start domestic processes. Now you have the process of supervision. In these processes of supervision, the court organizes people from the domestic society, from state institutions coming together, and they strengthen. That's the important thing. The state is not a unitary actor. The state internally, it's a very diversified thing, and then a decision by the Inter-American Court, it strengthens certain parts within the domestic system, and it helps those parts to further change. So the first reason is that the compliance, you cannot have compliance if you are really in the business of transformation. But what you then can have is impact. And what truly counts is impact and not compliance. So what you have to look at is what is changing in a country because there has been a certain decision. And one case where I have studied that more closely was the case Campo Algodonero in Mexico. You all know it was the killing of women in northern Mexico. And they created the figure of feminicide. It's a very interesting thing. It's the first time that you have an international bench composed by a majority of women. Yeah, it was 4-3. There were 4 women on the bench, and I think it was the first time that you had an international court with a majority of women, and they created that. But what happened after Campo Algodonero? Now they started teaching the police. Now you have human rights courses in almost all law schools in Mexico. You have a new mindset, you have new statistics, you have a new mindset to look at systemic violence. So the specific violence against women that you have in Mexico, now it has a cognitive frame. So you have the impact of a new cognitive frame in looking at that type of cases. So even though it is not complied with, it's still open and it's still in the process. You had a huge impact on Mexico, and I think it has been a positive impact that now everybody who goes to law school knows something about human rights, that you have the police that is taught, that the police now has to act much faster when when a woman is caught as disappeared. So the important thing is to keep the things going. And for that reason, and I think with that I want to close, is that it is so important that you build units in the country that operate with the Inter-American system. And I learned that now at the National Council of the Judiciary, for example. Now you have a unit of monitoring what is going on in Brazil, with the decisions that have, where Brazil is the addressee of a decision. And I think that is very important in order to use the energy that comes now from human rights, to use it to good end in the country. I think that is a very good practice. For that reason, and that then is my very last, no, I'm already done. Anyway, so the reason is, even if you don't have very excellent compliance, you can see in many instances that the Inter-American system, of which this House is a part, has a very important effect on societies. That's the end of my talk. Thank you very much for your attention.
Neste momento, será dado início aos debates. E para a mediação, tem a palavra Sua Excelência, o senhor ministro Luiz Roberto Barroso.
Eu consegui uma liberação aqui para falar em português. A cerimonial me pediu apenas para não falar em alemão, o que não haveria nenhum risco. Eu queria agradecer imensamente a interessantíssima palestra do professor Armin von Bogdandy, com um conjunto de ideias inovadoras que ele desenvolve há muitos anos, mas de certa forma, inovadoras para um público brasileiro. As ideias centrais que ele defende de que um diálogo entre a Corte Interamericana de Direitos Humanos e os tribunais constitucionais ou as Supremas Cortes da América Latina possam estar criando uma espécie de um direito constitucional comum latino-americano fundado nos direitos fundamentais. É uma ideia original, interessante, tentadora. A observação de que esse constitucionalismo transformador é capaz de enfrentar algumas das grandes mazelas da América Latina em áreas diversas de dificuldades que nós temos, desde habitação até circunstâncias mais complexas de concretização dos direitos sociais. E esse insight final, que é muito interessante, normalmente nós pensamos o direito em termos de execução das decisões. E se as decisões forem executadas efetivamente, ele funcionou, e se as decisões não forem executadas efetivamente, ele não funcionou. E um insight final que o professor Bogdandy trouxe foi a de que nem sempre se deve pensar, sobretudo no direito internacional dos direitos humanos, a propósito de se ter efetivamente executado, porque muitas vezes apenas aumentar o conhecimento de uma matéria e trazê-la para o debate público, inspirado pelo direito internacional dos direitos humanos, já é uma conquista, já é um avanço, já é um ponto positivo. Embora o Brasil não tenha propriamente feito parte dessa corrente latino-americana, um pouco porque a Corte Interamericana, pelo menos na minha visão, só mais recentemente passou a ser mais citada pela jurisprudência brasileira, não era muito visível o trabalho da Corte Interamericana, embora, então, esse fenômeno do constitucionalismo transformador latino-americano seja mais recente na percepção brasileira, a verdade é que nós tivemos alguns movimentos internos no Brasil que, de certa forma, se aproximaram disso que o professor Bogdandy chama de constitucionalismo transformador, que foi o movimento pela efetividade da Constituição, e como a Constituição brasileira é uma Constituição avançada em muitos pontos, a sua concretização produzia essas transformações. Em algumas áreas, nós conseguimos transformações importantes, sobretudo em direitos das mulheres, direitos da comunidade gay e ações afirmativas. E o neoconstitucionalismo que o professor Bogdandy mencionou, ele era mais a identificação de um conjunto de transformações que ocorreram no direito constitucional do que propriamente um projeto interpretativo, hermenêutico, como o constitucionalismo transformador que o professor Bogdandy explorou aqui. De modo que eu, em nome do tribunal e a pedido da ministra Rosa Weber, nossa presidente, agradeço de coração essa instigante palestra, e eu tenho aqui duas perguntas que já me chegaram e o espaço continua franqueado. A primeira pergunta do Raimundo, do CNJ e do Supremo, em que ele pergunta: haverá espaço para assuntos inclusão e acessibilidade? Eu entendo a pergunta do Raimundo: haverá espaço nessa ideia de constitucionalismo transformador para esses dois projetos de inclusão e de acessibilidade? Eu penso que seja isso, e como está tendo tradução simultânea, a pergunta foi feita em português, eu já passo para a intervenção do professor Bogdandy. Pelo que entendi, se há espaço no constitucionalismo transformador para assuntos como inclusão e acessibilidade, que é a terminologia que nós utilizamos geralmente no Brasil para assegurar os direitos das pessoas deficientes.
So I think that inclusion and accessibility, I take it a little bit more general to the legal system. if I can take the question in that sense. I think it is very important with respect to the question of inequality. Because in my understanding, inequality is not just a problem of scarcity of means and that some people are very poor and other people are very rich. But I think it's also with respect to access to public institutions, and in particular access to the courts. And if the legal system is developed in a way that even people who are in a difficult situation, and may it be for physical difficulties, but also for other reasons of their social situation, it is easier to them to access a legal system in which they have the feeling of having a fair treatment. I think that is a core element in addressing inequality, and therefore it is a basic element for social. I would answer that yes, it does have a space and it has an importance.
Muito obrigado, professor. A segunda pergunta está em inglês e eu vou dar, professor, um ligeiro background para ajudá-lo. A pergunta do Gabriel Neri é a seguinte: What's the difference between judicial activism and transformative constitutionalism?
Sorry, I switched now. Could you repeat?
Yes, sure. What's the difference between judicial activism and transformative constitutionalism? And let me add here, acrescentar aqui, para lhe dar um background, professor. Há um debate no Brasil grande sobre aspas. Oh, sorry, I'm giving you a hard time. So I'll speak in English. Okay. There is a major debate in Brazil about the so-called judicial activism. We have a very broad constitution that deals with very many subjects, as you know. And besides that, it's fairly easy to seek the jurisdiction of the Supreme Court through direct actions, meaning that the Supreme Court in Brazil gets involved in many issues that in other parts of the world are left for politics. But here, they are in the Constitution, and we don't have an option to educate or not the case. So there is a complaint that actually should not be addressed to the Supreme Court, but to the Constitution. It's in this scenario that comes this question. So if a court like ours, which is already accused, unfairly, I think, of being activist, how would the transformative constitutionalism fit in this model?
So, judicial activism, in my understanding, means that a court is deciding illegitimately, that it oversteps its power, that it goes ultra vires. Judicial activism is just another way of saying you're behaving outside your province, so that it is illegal and illegitimate. That is what judicial activism usually means. Now, transformative constitutionalism is something very different, because transformative constitutionalism can be exercised legally and legitimately. And I think in most cases it is a legal and legitimate exercise. Of course, there can be, any decision can be criticized and it can be decided differently. But whereas judicial activism means it is an illegitimate exercise of transformative constitutionalism means it's a legitimate exercise of judicial power. It's the opposite. Now, when it comes to whether something is to be left to politics, here the answer is that there is no fixed line between the judicial branch and the legislative branch. It simply does not exist that there is a predefined province what the courts can do and what politics is to do. That is something that is to be decided in any society at any given moment. And when you have to decide that, you have to look at the general situation of a society. And I will be the first to say that when a court engages in transformative constitutionalism, that is the second best solution. So in a perfect world, and also in a good world, you have a legislator who addresses the problem of a country. Unfortunately, in many societies where you have a fractured party system, where you have political instability, the political system and the legislative system simply is not able to address the problems of a country. So when a court starts dealing with transformative constitutionalism, the situation is that a country is in a very bad situation. And very often the courts are one of the very few institutions in the country that still can make the country move into a certain direction. So I think that the question, what kind of action a court can legitimately do, very much depends on the very situation a country is in. And here we have to see that in many questions, many democratic countries simply cannot, the legislator cannot react, and in that situation the courts step in. And we see that very often the country then moves that way. And we also see that there are a lot of techniques that courts can use in order not to finally decide a question, but to push the legislative process in a way that then a decision is taken with a specific legitimacy which enjoys only the legislator. So that would be my...
Thank you. Thank you very much. Very interesting answer. Just let me make a quick note here. When judicial activism in the original sense means when you use a constitutional principle that's vague to address one specific situation that was not predicted by the legislator. That's the original sense. But over time, it has acquired this negative sense that you mentioned, improper use of judicial power. But what happens in Brazil, like in any other part of the world where you have a constitutional court, is that the decisions, the border between constitutional interpretation and powers of the legislature are not very clear many times in Brazil, especially when you have a broad constitution like ours. So what usually happens, Professor, is when people are happy with the decision, they say it was good constitutional interpretation. When they are unhappy with the decision, they say it's improper judicial activism. This is what happens here. But I think this expression, transformative constitutionalism, it is very interesting because the Brazilian constitution is very progressive. It deals with education, with healthcare, with protection of indigenous peoples. So many times, interpreting the Constitution makes it look like we are being activist, but we're just applying the Constitution. So we are being transformative, not exactly activist. So that's a good way to put it. I have another question here from Gabriel Rodrigues Teixeira. It comes in English. Professor, do you believe the multinational legal similarities between Latin American countries may become even more important and noticeable in the near future, taking into account many challenges of our times are of regional or global relevance, example, climate change or the current energy crisis? You want to read it?
Yeah.
It's the first one, top one. You might need another lecture for that.
So the answer is that my knowledge of Latin America is very limited, and so here it would require to make a huge claim on how I would expect the various political and legal systems to develop. So I really don't feel that, because even the reaction to climate change, that really depends very much on what kind of government you have in place, and it can be that there is a government who thinks it's we have no stake in that process, and that they will not respond, and others will be very concerned in that respect. So it might be that the reaction to climate change in various countries can be very different. But it's also possible, and I think if I look at the Inter-American Court and I see the mentality that the Inter-American Court has, I wouldn't be surprised that the Inter-American Court would try to give some direction, common direction to the continent, and then there would certainly be that would certainly give an input to a common direction, and then the other forces would have to position themselves in that respect. But I wouldn't be surprised if the Inter-American Court came up with something to give common input.
Well, and interesting, there is a decision recognizing environmental protection as a fundamental right, as a human right. And just to highlight what Professor Bogdandy just said, in many countries in the world, maybe in most countries in the world, the fight against climate change is regarded as a political question. They usually dismiss the cases on grounds of standing or on grounds of political question doctrine, except for a wonderful decision by the German Constitutional Court, a recent decision, that based on intergenerational justice has decided that the fact that the current legislation leaves too much burden for the next generation, it's unconstitutional in this part, because they don't predict any special behaviors after 2030, which was an interesting decision. And just last week, we had an important decision here, reported by our Chief Justice, on the Amazonia, on the Amazon Fund, determining the government to resume this important project of spending in environmental protection in the Amazon. And the government had pretty much discontinued this fund, and the court decided it must resume it in 60 days. That was the powerful decision of Justice Rosa Weber. Just to say that in Brazil, because the environmental protection is a constitutional fundamental right and a duty of the state, unlike many countries where it's treated as a political question, here it was a legal question that was decided by the court. And I do agree with you that decisions by the Inter-American Court of Human Rights might give directions to the continent in this area. This is an area, as you know, that the majoritarian politics has not worked well, because they have short-term incentives, and usually the harm that the behaviors that affect climate only produce after 20, 25 years, so there's no incentive to tackle this quickly. I still have one more question, Professor. This one is in Portuguese. I'll try to translate it to make it easier. What do you think are the challenges to implement a culture, a transnational culture, of giving more importance to precedents? That's hard to translate. I'll try again. What do you think are the challenges to create a culture of giving more importance to precedents rendered by foreign courts, especially the International Court, I would say, which is a problem that let me highlight this, we do have in Brazil, not everyone accepting the jurisdiction of the International Court of of the Inter-American Court of Human Rights as binding.
Well, if it's a question of culture, it brings to education, because if you want to have a culture of something, it needs to be an embedded practice, and an embedded practice means that people are educated in a way. So if you want to have a culture, it takes that is taught at law school, and that it is requested. It is requested knowledge. So when people want to be judges or functionaries, that then there is an exam and they have to show that they know about it. So I think that is one element. Another element is that the decisions are written in a way that you can use them for a precedent. So they need a good ratio decidendi. Otherwise, you cannot. If there is no ratio decidendi, you cannot use it as a precedent, because there's nothing on which you can build. So it is very important that the courts develop a legal thought that then comes to a ratio decidendi, and then it is very important that that is possibly put out in a way that it is easy to consume. I think that is also an important element. And then, of course, a third element is that the decision of these courts are considered as legal and legitimate, so that it is conveyed to the legal staff, and that is to say also to the students, that what comes from these courts, that it is important, and that that these are decisions that are to be worked with. I think these are three elements that come to my mind in order to increase that type of a legal culture of international precedent.
Thank you. We still have 4 more questions here, and unfortunately, I'll have to stop with new questions because of our time. This one is from Carol Caputo, and she asks, is this transformative constitutionalism a new jus gentium, like the one that was created by the Romans?
No, because it's the jus gentium was a law focused on some very few elements of interaction, but the jus gentium certainly had not the idea of transforming any society. For that reason, I wouldn't think so. So it is more than just a law than just one country, but I think the impetus is a different one.
Thank you. This new one by Jorge Luis, he says, we live through a tense electoral moment in Brazil where democracy and fundamental rights have been threatened. Do you think that the role that the Brazilian Supreme Court played is seen as an example of a court acting for the protection of human rights to be copied by other countries?
So as I said at the beginning of this lecture, from outside, to the extent that I observed it, this court stood up in a way that many found impressive, and that many said that is an example that the hope that we had in constitutional court is warranted. As I said, it was that hope was deceived by a number of courts that we thought they would stand up, and they didn't. But here, the impression is that this court has stood up and had delivered what people had hoped.
Yeah, that's a very interesting point. Professor Bogdandy started his talk by mentioning countries where authoritarianism prevailed and courts were defeated, like Hungary, Poland, Turkey for sure, Venezuela for sure. And I think here we were able to stand up for democracy and establish boundaries that prevailed. That's a good comparison. So one more question by Tainá Garcia Maia. She's a researcher at University of Minster, And the question is in English, thank God. Are constitutional courts more dependent upon compliance for the purposes of legitimacy than regional human rights courts? That's the first question. I'll repeat. Are constitutional courts more dependent upon compliance for the purposes of legitimacy than regional human rights courts? And then a second one, if yes, would that lead to differences in the degree to which Latin American constitutional courts engage in transformative constitutionalism in comparison to the Inter-American Court of Human Rights? You might want to read this.
So on the first question, so I think every court is in the process of building its authority. To build authority, you have to go into conflict. Authority never is something that is only given, but you have to take it. So and I think the issue is less on compliance, but it's more on authority. So to be a court, and in particular a constitutional court, you need authority because your other means are limited. Now, if you to build and to build authority, you have to go into conflict, and you also have to go into serious conflict. Now, that is the first thing. Now, the second thing is then, with respect to compliance, is it different for a national court? Now, again, we need to see for a court which is, let's say, in a situation of systemic deficiencies. So let's take the Colombian Constitutional Court. So the important decisions of the Colombian Constitutional Courts, for example, the displaced persons, that is not a decision that has been complied with. Like many other decisions, they have not been fully complied with. But my impression is that non-compliance did not make that court less authoritative. So it's a difficult question, and I have to think about it more carefully. But I think it's not that a domestic court is more dependent on compliance. Even there, it's a broader question. And then it's a question of authority. Then the second question then is yes, would that lead to differences in the degree with which Latin American constitutional courts engage in transformative constitutionalism in comparison to the Inter-American Court? So I wouldn't see it that way. I think that the difference there, whether they are deciding in an international context or on the domestic context, the point always is, can we make a meaningful impact in a given situation? And can we do that while maintaining our authority? I think that is the core question, and less the question if there will be full compliance. If you have systemic problems, it's almost impossible to have full compliance.
Thank you. Thank you. So now we have the last question, Professor. Is transformative constitutionalism being applied by constitutional courts in Europe, for example, for the protection of the immigrants in these last refugee crises?
That is a hard question too, because so one element that for me is also crucial to transformative constitutionalism is that a society is dissatisfied with the way it is living. it is very autocritical. And that you have in those constitutional moments, there's a new constitution, and the legislator says we are in a situation that is not acceptable. So transformative constitutionalism usually is something in a situation where a country is very autocritical. That has not been the case in Europe. For that reason, for example, in my understanding, the Federal Constitutional Court is not a transformative court because there was never this general critical attitude with the situation of the country. Now when it comes with the situation of migrants, so I would agree with people who say that the situation of migrants in, let's say, on the Greek islands, where you have thousands of people living in terrible situations, that there is a systemic deficiency. However, so far, there have been no courts who truly address that issue, so that they have found the way to take up the challenge to be a transformative court for a situation that is systemically deficient. Where we have that now, and that is the first truly transformative move in Europe, is that the European courts both are addressing the situation in Poland. So that is the first time that I would say European courts are really moving into the business of transformative constitutionalism, and that is something that I think that they can learn a lot from Latin America.
Thank you. Thank you very much, Professor Armin von Bogdandy, for being here with us this afternoon and sharing your thoughts, your ideas. It was very enlightening, and I want to thank you for being here. I want to thank our Chief Justice, Justice Rosa Weber. She has a very heavy schedule, I can tell you, but she took the time to be here and listen to you. And I'm sure she didn't waste her time. I'm sure that she profited from being here, as we all did. So we want you to have a nice stay in Brazil, a safe trip. He's going to Chile tomorrow, right? To Chile. And I ask everyone for a warm round of applause to Professor Bogdandy.
Thank you so much. Thank you.
Agradecemos a participação de todos. Com a devida autorização, declaro encerrado este evento. Tenham todos uma boa noite e uma excelente semana.